My friend Richard Rios and he's a partner at a local law firm that does political and election law, Olson Remshow. And he and I want to see the Fair Political Practices Commission's rulemaking have greater transparency. In fact, we think the legislature should enact legislation to require the Fair Political Practices Commission, the FPPC, to fully comply with California's Administrative Procedure Act, the APA. Now, the FPPC takes the position that it's only bound by the version of the APA that was in existence in 1974 when the FPPC was created by the voters who adopted Proposition 9 that enacted the Political Reform Act of 1974. We, however, believe that the FPPC should be bound by the current version of the APA. The FPPC, after all, is focused on transparency in the political and election processes. However, without compliance with the current and entire APA, the FPPC's rulemaking or regulatory procedures are not conforming with contemporary standards that other state agencies and departments are required to follow. The APA was substantially amended by the legislature back in 1979. And of course, it's been modified in numerous instances over the past 40 years. One of the legislative findings and declarations that's contained in the APA says there's been an unprecedented growth of unclear and unnecessarily complex administrative regulations. And of course, the legislature established the OAL, the Office of Administrative Law, to ensure that state agencies and departments and their regulations are written in a comprehensible manner and that they're authorized by statute and consistent with other laws. Since its original enactment, there have been quite a few changes to the APA in the legislature's continuing efforts to ensure transparency in the rulemaking process by establishing a number of procedural requirements and standards for state agencies and departments when they adopt their rules and regulations. Now, you may not be aware, but in 1992, the FPPC filed suit requesting declaratory and injunctive relief in a superior court, and they argued that they were not bound by the post-1974 amendments to the APA, such as provisions that granted OAL the authority to substantively review FPPC regulations. Unfortunately, in an unpublished decision, therefore it's not citable, the Third District Court of Appeal held that the post-1974 APA amendments don't apply to the FPPC. The court basically reasoned that the citation to the APA in Government Code Section 83112, which is found in the APA statutes, was intended to reference the specific statutory provisions in the APA rather than serve as a general reference to the APA, including any amendments adopted post-1974. So the appellate court in that unpublished decision reached its determination despite what appears to be a clear intent of the voters to subject the FPPC to the APA. If you look at Government Code Section 83112, it reads, "The Commission may adopt, amend, and rescind rules and regulations to carry out the purposes and provisions of this title and to govern procedures of the Commission. These rules and regulations shall be adopted in accordance with the Administrative Procedure Act and shall be consistent with this title and other applicable law." In response to this unpublished court decision, the FPPC adopted in Title II of the California Code of Regulations, Section 18312, that provides that the FPPC is subject to procedures in the APA that were in effect as of June 4th, 1974. And unfortunately, this FPPC regulation remains in effect today. I don't think that this should remain the law of the land. Instead, the legislature should require the FPPC to ensure that the FPPC's processes and procedures for adopting rules, regulations, and other administrative materials comply with the modern standards of transparency and public accountability that apply to nearly every other state agency, except those where there's an express statutory exemption. Compliance with the current version of the APA should be done to ensure that public policy objectives are obtained. For example, it would provide more time for those who are affected by FPPC regulations to review and analyze those proposed regs. Also, the APA requires an agency to respond to objections, recommendations, and even proposed alternatives that are identified during the public comment period. Finally, the APA requires proposed regulations to be reviewed by OAL to ensure that they're clear, necessary, legally valid, and available to the public. Fundamentally, having the FPPC comply with the current version of the APA will ensure compliance with these modern standards and improve the FPPC's rulemaking process by ensuring that its adopted regulations are valid and responsive to legitimate public concerns. If the FPPC is, to demand transparency and accountability by those who are regulated by the Political Reform Act, so too should the FPPC be subject to the highest standards of transparency and accountability that are imposed on executive branch agencies and departments throughout the state of California.